Mr. Serangeli, we welcome you this afternoon, and we're ready for your opening statement.
Thank you, Justice Wiggins, members of the Commission. First of all, I want to thank you for taking the time to allow me to speak to you today and express my appreciation for the task that's before you, and that is to discern from over 6 candidates a group of 9 people who you believe would be qualified candidates for the Supreme Court. The Supreme Court, in my knowledge, has always been an adjudicative body, basing its ability to function upon who can build a consensus. There is not one member of the court more important than all 7 members of the court. And thus the court functions on the ability through its conferences to have a consensus arrived at with regard to what is in the best interest of the people of Iowa, applying the gracious gift of our common law and the wisdom of our own state constitution. As a trial lawyer for 36 years, I have learned that very same task and result orientation. When you pick a jury, you learn quickly that the only way you can be successful with regard to the advocacy of a position is to build a consensus amongst some of the jurors and then work throughout the course of the trial and through argument to expand that consensus to a controlling majority, which in a civil case is 7 people after 6 hours. I certainly applaud the court's new efforts, and I use that probably a little more liberal than it need be, with regard to its increased visibility. I believe in that function as well and support it and want to do everything I can, if given the privilege of service to the people of Iowa, to increase that visibility. Our courts have always been open. There has never been a locked door to a courthouse. I can remember once trying a case when the jury verdict came back after 4:30. The result was we waited an hour before we'd allow the jury verdict to be read so we could ensure ourselves that the courthouse was unlocked and it was open to the people of Iowa. Chief Justice of this court has done a marvelous step in increasing the court's visibility by going on Iowa Public Television. I wholeheartedly support that. Also, to the extent that the canons of ethics allow it for judges, I believe they should go outside of the customary shell of speaking to law groups, in which we're all very, very comfortable with old friends and old procedures, and speak to more civic organizations in the districts in which they administer. That would give to the court, I believe, the increased visibility that the public wants at this point in time. And finally, I am an avid fan of the common law of the state of Iowa and an adherent to the Constitution of the state of Iowa, which I believe is the people's ultimate voice as to how they want to be governed. Thank you.
Thank you, Mr. Serangeli. Let's start on the right side over here, and I'm sure Mr. Fitzgibbons has a question for you.
Thank you, Justice Wiggins. Good afternoon, Mr. Serangeli.
Good afternoon, Mr.
Thank you very
Sims.
much for being here today. We appreciate it greatly. And I've had an opportunity to visit with you. I've had an opportunity to review your very impressive series of informations that you provided to us. You've been a very solid student, maybe a few years ago. Time gets away from all of us. I'm just curious, you've done a lot of things, a lot of different areas of law. You've distinguished yourself at the trial bar. Tell me, if you were chosen as a justice of the Supreme Court, is there any particular jurist, any particular judge, Supreme Court justice that you think through their rulings, through their work, through their personality, a person that you would like to emulate yourself?
Yes, Ward Reynolson.
Tell me about that in a little detail.
I was much younger, and as I tell my grandchildren, I used to have hair. And right when continuing legal education came forward, we had to start getting our hours in. And I went to a seminar that was presented in the 70s by the Iowa Academy of Trial Lawyers. And at that seminar, a district court judge who no longer shares life with us was somewhat critical of the trial bar. And I noticed that Chief Justice Rendelson was in the room, and he was becoming uncomfortable. And after this 55-minute presentation and the stand-up break, and everybody went and got coffee or a soft drink, Justice Rendelson spoke to us. And he said, the one thing I'll never forget being a justice is that without a trial bar, I don't have a job. And that stuck with me. That humility, that just absolute ability to reach out and never forget that while you may wear a robe, you're still a lawyer. That just stuck with me. And that's why I admired him all the way along his career. It's one of those defining moments that you sit down and you think about, and you actually say, if I would get this job, I want to do it that way.
Any other questions on this side? Professor Corcoran.
Thanks for coming today. You spoke to the short-term issue of the Supreme Court needing to reach out more and public legitimacy and those sorts of things. Also, as part of this administrative function of the courts, I wonder if you can speak to your experience of 3 decades sort of in the Iowa court system. What are some of the things the Iowa courts do well? What are some of the things that are working correctly? And what are some of the things that long-term, the next decade or so, we're going to have to keep in mind and adjust to?
The one thing that the Iowa courts do very well is the philosophy of the courts and the judges is totally dedicated to making sure that there is no rush to a judgment and that everyone has their day in court. During the flood of '93, I was on the Polk County Bar Association Bench Bar Committee, and we had no courthouse, something that people in Lynn County and other areas of the state have experienced. And we had a meeting in West Des Moines on some high ground where we actually had potable water. And then 5th Judicial District Chief Judge Moore was concerned about the fact that hearing after hearing after hearing had been canceled. Because in Polk County, every day, Monday through Friday, from 8 to 9 o'clock, the judges have hearings. And I, as chairman of the committee, said, well, Your Honor, why don't we just deem all those matters to be submitted? And that way the courts can work on that backlog. And he looked at me and he said, absolutely not, Bill. That is not going to work. The people of Iowa expect more and they'll get more. And that is a tribute and an attitude that I believe separates this court system, the Iowa system of justice, from many of its sister states. The men and women who serve this system really do take to heart service. The long-term concern that I have for the court is we address and want the courts to be more accessible to all people. We want more pro bono, which is absolutely wonderful. We tinker with the idea that what are we going to do? Are we going to increase the small claims limit from $5,000 to $10,000 to $20,000, subject to a constitutional amendment that assures that that's a right to fair trial? But the balancing with regard to that concerns me is, where is the human resource going to come from? No matter what advances that we make in technology that assist our clerks, our law clerks, or even our ability to load up a brief in a computer rather than our backpack or our computer, the soul of judging is the intellect of the men and women who make the decision. There is no way that soul can be enhanced by the internet or by technology. Our system will always be totally dependent on the intellect and integrity of those who wear the robe.
Any other questions from the side? Mr. Mickelson?
Mr. Serangeli, tell me a little bit about your family and how they may have affected your decision to take this opportunity.
Well, I have the total support of my family, and that's the number. As you notice, my daughter is sitting back behind there. She's helping me out because Dad's a little nervous, which is rare for a trial attorney. Trust me. I mean, we usually like being on stage, but
Now we ask, you want to do jumping jacks or anything?
no, no.
All right.
My father was the firstborn of an immigrant family, and he always taught me, you're going to get up in the day, and you're going to have to figure out what you've got to do. You've got to make a list, because you'll forget. And believe me, now I know what he meant, because I do make lists. And he said, the one thing you have to understand, son, when you approach anything, is do the difficult job first. Don't do the easy one first. Do the difficult job first. Use the energy you have to get it out of the way. And he used to say, if you do something half, and I'm not going to, he said, don't do it at all. I will not tolerate that. And so he also said, just share. If you have a talent, share it. And he was a big guy. He was 6'2" and a veteran of the Korean War and the Second World War. I have my mother's height. She was 4'11". But that was something that always shaped me, was the idea that, you don't run from work, you go towards work, because it has to be done. And if you complain, the only thing you're really trying to do is avoid doing the job anyway.
Any other questions from this side of the table? How about the other side? Mrs. Skogerson.
This message is for your daughter. Your dad and I had my first and only jury trial together in my second year of practice, and he schooled me, but he was a gentleman about it. Mr. Serangeli, we, as you probably know, have a number of candidates from the Des Moines area, and I think that the entire commission has a concern as to whether we're adequately representing geographically the state of Iowa. So what can you tell us that might distinguish you from the other Des Moines attorneys in particular, and how you feel that you have and can continue to maintain touch with the other areas of the state?
Well, it is really hard to say that you can be distinguished from the names that I've read in the newspaper. I haven't seen the materials that you have, but I tell you, I recognize those names, and there are some just absolutely marvelous candidates. And I hope that all of them share the same desire that I do, to actually serve as a member of a court, not as the court. I'm fortunate enough in my practice currently that I go all over the state. Tomorrow I go down to Fairfield to try a jury case for 5 days into next week. So I keep in touch with the parameters of the state, as we call it. But I get envious. On a motion day in Mount Ayr, the attorneys are in the courtroom, they're having a cup of coffee, and they're sharing stories about their kids, they're sharing stories about their cases. They say, has anybody had one of these? And you watch, and everybody's talking about it. I can assure you, we don't have that here in central Iowa. There's no motion day gathering of lawyers kibitzing with regard to stories and building those relationships. You go to Algona, and it's the same way. You go to Humboldt County, it's the same way. You go to Clarion, where I've been, and there's a welcomeness about all members of the bar, and I enjoy it immensely. And if granted the privilege of serving, I understand that there is a supervisory duty with regard to various districts, and I intend to go to those motion days and have a cup of coffee. I also intend, since I need to be a student of everything that I'm charged with administering, that maybe before I have any bright ideas about how things could change or be made better, it might be a little bit better to sit on the stool in the clerk's office towards the back and watch what goes on before I tell people how to do their job. In other words, just continue to be the student.
Mr. Brody?
Good afternoon. Thank
Good
you for
afternoon,
being here. I also want to thank you for your service to the practice of law and to the community. How will you make the transition from being an advocate to somebody who has to adjudicate the law, administer the bench, write, do all the public outreach? How are you going to be able to balance all of that? Your background.
My background has been as a trial attorney, and as I tried in my opening statement to elicit, is that I'm used to the idea of having to build a consensus, having to build upon building block one step at a time with regard to obtaining a goal in terms of adjudication. I believe that the court, with over 150 cases a year, is a very adjudicative body. There's a give and take in that room as to what goes on, and I don't think the learning curve for me is going to be that big of a learning curve. I'm not one of these lawyers, although I name myself like, I'm not a screamer. I'm a doer. I do my own research. I do my own writing now. And the reason for that is I don't want to get in front of a court, in front of Justice Wiggins, or in front of an arbitrator, and make a statement as to the law and find out that the person who gave me the memo doesn't know what they're talking about, and so that means two of us don't. I also run a small business. Candidly, the business of the court system is far larger than my office. Although there are mornings like this morning when I was in the office, I thought, how could this be any more of a problem? But I got through it. And so I'm used to administration. And I have a firm belief that you never talk at someone. You only talk with people. Because it's by doing that that both sides learn. And that's a skill that I have and will continue to use if this privilege is given to me.
Mr. Holm, I think you had your hand up.
Thank you, Justice Wiggins. Mr. Serangeli, you've had a great career as a trial attorney, and this may be sort of a follow-up on what Mr. Brody asked you. But what do you see, what is it about being an appellate court judge? Because the day-to-day work of that court would seem to be so much different from being a trial attorney. What is it that attracts you to serving as a Supreme Court justice? What do you think you'd like, and what do you think you'd bring to it?
I believe what I would like is to work in a collegial atmosphere with people whom I respect and with a common goal of providing justice for all the citizens of the state of Iowa. As a trial lawyer, I deal a lot with the adversary system. I know it, I appreciate it. I might have just now grown enough that I can go on.
Mr. Cook?
Thank you, Justice Wiggins. Sir, you have a very impressive background and accomplished many things as a trial lawyer. And you've exhibited here today that you're a very thoughtful and humble fellow. Tell me what you think of this process and the fact that we've opened it up for the first time and your materials are made public and you're being questioned in the public on the internet.
When my wife and I sat down and made the decision that I was going to do this, I knew it was going to be public, and I welcomed that. I want you to know that I'm a little disappointed by the attendance, and I hope that the internet viewing is far more demonstrative of the concerns and interest of the people of Iowa than the actual attendance. I can't think of a better way for people to judge the sincerity of the work that the commission does than by having this open to the public, and to judge the caliber of the people that have come before you, and the difficulty that your job is going to be in finding 9 people to give to the governor, saying, these are the 9 that we think will assimilate into the court and allow the court to be back at full strength. There's nothing about this process that has bothered me. I knew it was going to be open. I hoped it was going to be open, and it is open, and I take great comfort in that.
Thank you.
Any other questions? I do want to disclose to the court that Bill and I started in the same law firm when we started